Good evening to all our joining libraries. My name is Frank D'Alessandro, and I'd like to welcome you to the Volunteer Lawyers Project video workshop series on civil legal topics. This evening presentation is about the rights of tenants in Maine, and there will be a question and answer period after I've reviewed some of the basic information and procedures that might be useful to you. Please remember that I cannot give individualized legal advice to anyone during the workshop, but I will be able to answer general questions about the legal issues and procedures. If you would like further information about the video workshop, please ask your librarian about connecting to the Help Me Law website, where you can access legal information and other legal resources. Please make sure that you have signed in and that if you fill out all the evaluation forms at the end of the session. You do not have to give your name, but we do need statistics and we seek your feedback. I'd like to thank you all for being here tonight. My name is Frank D'Alessandro. The one takeaway I want to make sure everyone comes away from this meeting, this presentation is, as a tenant, you cannot be forced to move from your rental unit until your landlord takes you to court and a judge orders you to move. And that's regardless of what's in the notice to quit you may receive or what may be in any lease agreement you may have signed. So there's 4 areas I'm going to try to cover tonight. One is your right to live in your rental unit and what that means. 2, your right to live in safe, decent housing. 3, your right not to pay for someone else's utilities, such as heat or electricity, or for heat and electricity in common areas. And 4, your right to get your security deposit back. Your right to live in your rental unit. As I said before, and as I'm going to say again, you have the right to live in your rental unit until your landlord takes you to court and a judge orders you to move. Now, what rights you might have beyond that depends on the type of tenancy you have. And there's 2 basic types of tenancies in Maine. One is a tenancy at will. A tenancy at will is a tenancy where there's no lease agreement. You didn't sign anything. You have a verbal agreement with your landlord to live in the rental unit. This other type of tenancy is a leasehold tenancy. And that means you've signed a written agreement with a landlord to live in a rental unit. And in order for it to be a lease, the lease has to have a begin date and an end date. Okay, it cannot be a lease that never ends. For instance, a lease that does not, a written agreement that does not have an end date is not technically a lease agreement, and you'd still probably be considered a tenancy at will under Maine law for most purposes. Now, if you're a tenant at will, before your landlord can evict you, the landlord has to serve you with what's called a notice to quit. And there's 2 types of notices to quit that a landlord can serve on a tenant who's a tenant at will. The first is a 30-day notice to quit. And there doesn't have to be any reason for that notice to quit. It just has to say at the end of the 30-day period, you need to leave the apartment. Now, the 30-day notice to quit has to expire after a date for which your rent is paid. So if you already paid your rent for September, your landlord can't serve you with a 30-day notice to quit that expires before the end of September. The other type of notice is what's called a 7-day notice for tenants at will. And that would be for cause. That means you did something wrong, like the tenant caused a nuisance in the property or the tenant didn't pay his rent. If it's for non-payment of rent, the notice to quit has to give you a right to cure, which means, let's say you haven't paid your rent for the month, you owe $200 in past due rent. If you pay the rent within the 7 days, the landlord has to let you stay there. If you caused a nuisance, there does not have to be a right to cure in the notice to quit. And at the end of the 7-day notice to quit, if you're still in the apartment, then your landlord has to take you to court, and then the landlord has to prove that they complied with the statute and that they can prove to a court that you actually caused a nuisance. So there's also another type of lease. So there's two types of leases. One is a lease where there's no subsidy, no government subsidy, like Section 8 or public housing. And then the other is a lease that does have a subsidy with it, like Section 8 or public housing. The type of notice you're entitled to before you're evicted, if you're in a leasehold without a subsidy, depends on what the lease says. So the lease can have a notice to quit provision that's as short as 1 day, or it can require a 30-day notice to quit in all cases, even for non-payment of rent. Basically, whatever the notice to quit requirement is, whatever the lease says it is. If there is no notice to quit provision in the lease agreement, then the landlord has to serve you with the same notice that you would be entitled to if you were a tenant at will. So they would have to serve you with at least a 7-day notice for non-payment of rent and a 7-day notice if you cause a nuisance. Now, if you have a lease that has a subsidy, the rights you have are as determined by the lease agreement and also by the laws that govern the subsidy. There's two major types of subsidy. One is a subsidy that goes with the unit. So that's the most common example of that is public housing. So the unit is what's subsidized, and you get approved to occupy that unit. The other type of subsidy is what's called a voucher, and the most common type of voucher is what's called Section 8 vouchers. If you have a subsidy that goes with the unit, typically you can only be evicted if you've done something wrong. And so you have to have violated the lease agreement in some way in order to be evicted. If you have a subsidy that goes with a voucher, during the term of the lease agreement, you can only be evicted if you've done something wrong. But at the end of the lease agreement, the landlord can decide not to renew the lease agreement. And the landlord does not need a reason not to renew the lease agreement. Typically, if the subsidy goes with the unit, like public housing, you can only be evicted for cause even if the lease agreement expires. The landlord cannot just choose for no reason not to renew the lease agreement if the subsidy goes with the unit. If you do have a subsidy, it's really important that you protect the subsidy. A Section 8 subsidy limits the rent that you pay to basically 30% of your income. It's a very important government benefit, and it's very important that you protect it. Typically, if you violate the lease agreement, you can lose, most programs, you can lose your subsidy, and you don't want that to happen. So you want to do whatever you can if you have a subsidy to keep it, to make sure that you pay your rent, to make sure you don't cause damage to the unit, and make sure that you comply with the lease provisions so you keep your subsidy. Another government assistance program that helps people in landlord-tenant situations is general assistance. A lot of people use general assistance to help pay their rent. A landlord cannot refuse to accept general assistance. If you try to pay your rent with general assistance, there's a law that says the landlord has to accept it, and that payment with a general assistance voucher has the same effect as paying with cash. If your landlord tries to move you out of the apartment without taking you to court, that's called an illegal eviction. If your landlord tries to do that, you need to try to call the police. You need to show the police evidence that you have a tenancy, such as a lease agreement, or if you're a tenant at will, something like a rent receipt, to show that you have the right to be there, and your landlord has to take you to court before your landlord can force you to move from the apartment. There are some misconceptions about when you can be evicted. You can, in Maine, be evicted in the winter. There's no law preventing you from being evicted in the winter, even if you have children. In Maine, you can be evicted for not paying the rent. It doesn't matter why you didn't pay the rent, as far as the court's concerned. If you lost your job, it may be a good reason that you didn't pay your rent, but that's not the landlord's problem.